Right. I think the YouTube connection's having a slow and leisurely evening as well at the moment. Right. I just want to make sure it's happening, and I think it is now. Well, that's great. So we're streaming live to YouTube now, and I'll need to make sure that's muted up over there. Perfect. Okay. Let me come back to you, Andrea. And would you mind just collapsing your presentation for just one moment so we can see you and talk to you? It'd be lovely to get to meet you and learn a bit more about you. We know Daniel, of course. Good evening to you, Daniel Reis of Reis Pellicano. And Andrea joining us tonight. As you can see on the screen at the moment, international wills when living in Portugal, key considerations. So first and foremost, Andrea, thank you very much for being with us to talk about this very important subject. And I think maybe it's a really good place to start would be to actually underline why this is so important, because at any time in most people's lives, with writing a will, it's like, well, I'll get round to it. I'll get round to it. And eventually they do. And it's obviously a very good idea to do so. But there is an added dimension, I think, here in Portugal, is there not, if people don't take care of this? So would you mind very briefly, just by way of an introduction to the importance of what we're talking about tonight, let us know why it is so important, specifically because of being in Portugal?
Firstly, I would like to thank you for having me here and to come and talk about this very important subject. So in short, what we have been facing is the entering the country of third parties and citizens from all over the world. And we do in Portugal have indeed a very, very complex succession system. Why is it important for us to talk about wills? Because if the person lives in Portugal and dies here, the Portuguese law will be applicable to all their assets. This means whatever is able to the people having in their foreign and nationality countries will not be enforceable in Portugal. So I will talk about this further on. But in short, this is the main question. Leaving a will in Portugal that can state these issues.
So super important, basically, and we'll dive deeper into what that means and how people can go about it. So thank you for being here tonight on this Expats Portugal webinar. Andrea Gonçalves, we've got Daniel dos Reis with us as well from Reis Pellicano behind the scenes too. And I know tonight we're going to cover exactly what you just mentioned to us there in summary, the law, how to go about it, the specifics of it as well. And of course, any other questions that may come up in the chat, I will field those and put them to you. So let's get started with a brief presentation that you have for us as well, which sets everything out, I think, in an easy to understand way.
That's it. I'm going to share my screen with you. I did really try to make it a brief presentation. So hopefully we will get through it. Just one moment more. Oops. And here we are.
You can see the details there as well. So obviously reach out to Andrea and to Daniel as well. You can find them in the Expats Portugal business directory. And reispellicano.com is the website address. So back to you, Andrea.
Yes, thank you very much. So today I will be presenting you some key considerations about international wills, especially for people living in Portugal. I would consider also that everyone who has assets in Portugal may think about these considerations as well. Although they might not be of such importance as living in Portugal, I'll get to it, why everyone who has assets and who is not a Portuguese citizen should have these key considerations in mind. So in short, this question about wills and international wills are quite important because we have an increasing number of individuals that are relocating globally for all kinds of means, education, employment, established families, and whatsoever. So not all, and also about this, they have established here in Portugal and also purchased assets, bank accounts, vehicles, boats, plots, houses, all that you can think of. And so this is, once again, the summary of this theme. I would like firstly, and before entering to what is a will, how you can draft it in terms of not a Portuguese citizen, but an abroad citizen or third-party citizen, I would like to show you a little bit of our very, very complex legal system in terms of succession law. Our civil code is the code that talks about and gives us all the rules about these matters. Firstly, if we read the civil code, we will say and hear that they tell us that the law applicable to succession is the personal law of someone. And what is the personal law? It is the law of their nationality. You might say, why are we talking about this? Is if our civil code says this, because I will present you a European regulation that will say that no, it's not the law of the nationality, it is another law. And then we go to the complexity of our system. In Portugal, we do have forced heirship. This means that a person cannot choose freely to divide their assets. They can in a portion, and that portion is 1/3 of their assets. But in relation to the other 2/3, they cannot do what they want. They have to leave it to their spouses, to their children, and to other people. This is like a tree. If you do not have the first one, you pass on to the second one, and thereon. And these are the two main issues that our law has, that we are not able to remove them, even if we had a Portuguese will. For example, myself, as a Portuguese citizen, if I do leave a will, I can say what I want to do and how I want to do it, but I also have to have in consideration 1/3 of the assets and the forced heirship. This is why afterwards, and let me get back to the applicable law, because of everyone entering and European regulations and the fact that every country had different understandings about the applicable law, the European organs have decided to create a regulation, a new one, that regulates in the European Union these matters. And this is where the applicable law changes a little bit, because now, since 2012, we do not consider for succession laws the law of the nationality, but we consider the law of the habitual residence of people. This changes a lot. Why is that? If you decide to become a fiscal resident in Portugal, you live here 5, 10, 15, 20 more years. And if we are able to prove that the habitual residence was here, then if you do not say anything, the Portuguese law will be applicable to you. This means that all that you have decided in wills in any other country, not only the nationality country, will not be enforceable. And so this regulation, I would like to say that the regulation only applies to succession matters, which mean that when we're talking about tax matters, civil subjects that can be related to succession, for example, marital regimes, donations, and other subjects that you may think of and may be related to succession, are not ruled by this regulation. This regulation only is applicable for succession matters. And to this, Something very interesting and related to tax matters is that the Portuguese law, as I have said, will be applicable to the tax matters. So we will have here a double application of laws. The law of the nationality, for example, for the succession matters, but in terms of tax matters, we will have to see what the Portuguese law says. Also by this regulation, and if we read Article 22nd of this regulation, I'll just read it very shortly, that one person can choose as the law to decide all its succession, the law of the state of which the person is national. So here we have the possibility to choose another law rather than the Portuguese one, but only for the purpose, and it can only be the law of the person's nationality. You may also ask me, what if I have two or more? Then lucky you, you can choose whatever one you would like. And in short, this is the great thing that this regulation allows us. It's very important because most people do have wills in their countries, and it normally is the countries where they are nationals from. This is also important because we are not able to pick your will abroad and translate it to Portugal for it to be enforceable. So the only way you can do that is having a will in Portugal where you will say, I want the law of my nationality to be applicable to all my assets. It's not only the Portuguese ones, it will be all of them. Okay. And then here you might say, do I always have to do a will in Portugal? This is one of the questions that I am asked the most. And I will tell you, you should always think about a will in Portugal when you do have assets, but it's not mandatory for you to have a will in Portugal. And we will see with what I have presented here. What happens to my will in other countries? The first thing to answer, as we have seen, is my fiscal residency in Portugal? If it is not, the applicable law is the law of the nationality, of the person's nationality. If the answer is yes, I do live in Portugal, then the question is, did I sign a will in Portugal where I chose the law of my nationality to be applicable to my assets? If the answer is yes, then the foreign will is applicable in Portugal in the exact terms, meaning that the person who will open the will afterwards will have to send it and have to inform the authorities of the nationality process that there is a will, all of the assets are being divided as per the law of the nationality. If the answer is no, I lived here, but I do not have a will here, I passed away here, and it is proven that my fiscal residency was here, then unfortunately, you will not be able to apply to your succession your nationality law. It will be under the terms and laws of the Portuguese legal system. And this is quite important because you may see all dispositions that you left in a will not applicable at all. Imagine, for example, if you leave all your assets to a friend in a will, I imagine in the United States, and then the person comes to Portugal to live here and unfortunately dies here with no will. When you open the US will, as that is not possible under the Portuguese law, we cannot make the will enforceable. Okay, and this is and sorry to go a little bit backwards. Let's go back here to, is my fiscal residency in Portugal? And we say no. Although it is not mandatory for you to have a will, it is mostly advisable that you do. And why is that? In Portugal, we have not only a complex system, but we also have a bureaucratic system. If you leave a will choosing the law of your nationality, and at the same time, we state what you want to do with your Portuguese assets, your heirs in the future and the people who you leave your assets to will have it will be much more easier for them to register the assets in their names. So the transfer of assets will be much more easier. In short, it's not mandatory. My advice is that a will is always done in these circumstances. Okay. Overcoming all these little issues, we come to what is of main importance. So I have decided that I want the law of my nationality to be applicable. I have decided that I do want to know, do want to leave my assets to determined people, and I know how I want to do that. So what is needed? What do we need to have a will? First, I would like to tell you that a will is a personal act, and we do not have the figure here in Portugal of common hand wills. This means that the spouses, for example, have to do personal wills, each one of them. We do not have a figure of joint wills. Also, people will have to express their statements, which one they are, firstly with the law of the nationality and secondly with what they want to do, personally. This means that they have to come to a notary in Portugal and state it. Here, wills are only done in notaries. I know that in other countries, notaries do not have the power, or at least the importance that they do have here in Portugal. However, because of this is of major importance, the only people who are allowed to perform wills and archive them in their offices are notaries. They are the ones that are entitled by the state to have a will done. So in short, for example, a lawyer can do and perform a deed, but we cannot perform at all at the end a will. And this here, there's another question raised. So why do we need a lawyer? And I'll tell you very shortly. You do need a lawyer because we are the people who will be working directly with the notaries and who will draft the wills. So in parallel, we will help you decide what, you will decide what you want, you will let us know, and we will communicate to the notary so that the will is drafted in the exact terms you want. Just a little note here, and I think it's better to discuss it, that in most times when people let me know, Andrea, I want this to happen, I want that to happen, and there's the figure of trusts, who abroad are very, very common, but they are not understood and they are not legal here in Portugal. So we do not have the figure of trusts, they cannot be used. We have to find another way of doing things as the person's wishes. Also here, to do the will itself. So after all these processes that are done in office, then we go to the notary and we sign the will itself. What do I need? Personal documents, personally having to go to the notary, and then if the person does not understand Portuguese, we will need a translator, and we will also need the presence of 2 witnesses. These witnesses have to understand Portuguese clearly, cannot be at all related to the person who is going to sign the will, and the witnesses cannot be related in family ties with themselves as well. So in short, I would say can be friends of the person who's doing the will, but they cannot be family related and cannot at all receive anything by that will. So 2 independent people, let's say that way. And in short, this is what you will need, and this is how the process will occur, and all steps done. In the end, you will be granted a certified copy of the will, because the original version of the will always be kept in the notary's offices. One last thing that I do think is of major importance related to wills and how we can combine this with any other will. At any time, a Portuguese will should revoke any will that you have made previously. The Portuguese will have to work in parallel with any will that you will have anywhere in the world. If it is stated anywhere that you revoke it, then you are revoking the wills abroad. So that's one of the other pieces that you should have a lawyer accompanying you, because things have to be stated very clearly. No revocation. What is intended is the will is parallel to any other document you may have. And with this small presentation, I think that, with this small presentation, I do think that I have come through all the main issues and all the main points of having a will in Portugal.
I think you've done a great job there, Andrea. Thank you. That flowchart is especially brilliant. So it really is. It really is, because it's actually quite simple when you know how, isn't it? But when you don't know, you could be leaving yourself open to all sorts of trouble. And I guess in the industry that you're in, you do hear about the pickles that people do get themselves in if they don't take care of these basically quite simple things, but it's knowing what to do and making sure that it happens. So thank you for telling us the theory, how it actually happens, how you find two candid friends who are independent and not benefiting from the will. That's quite a challenge, isn't it? But that's a reason. That's a really good reason to make friends on the Expats Portugal forum and in the community as well. But that could be quite a challenge, I think, for some expats, couldn't it? As a side note there. So thank you very much indeed. Really helpful. We will have a session whereby the Expats Portugal members here can ask you more informal and personal questions. What would be great before we finish that, though, is to learn a little bit more about Reis Pellicano, the company we're dealing with. So who better to do that, perhaps, than Daniel in Lisbon? I wonder if briefly, Daniel, you could tell us about the company that people will be dealing with here.
Hello, once again, Carl. Reis Pellicano, we do have offices all over the country, so Lisbon, Porto, and Faro. So we are closer to the action, as we deal a lot with real estate, as well as with these types of situations like international wills. We do cover the islands as well. If needed, we go to the islands. That has happened quite a lot in the past, in the recent past. And we do cover all the needs or legal needs of expats in Portugal. And the majority of the needs are indeed the international wills, Portuguese nationality, incorporating in Portugal, and all the rental agreements, property acquisitions, all that can be handled by a law firm. And depending on where the client is, you will be directed to the office that is closest to you. So you always have someone that you can go, and instead of traveling from Porto to Lisbon, you can just meet lovely Andrea in the Porto office. Or if you are down south, you can meet Patricia, who runs the Faro office. And we are targeted or geared to expats, and I would say mainly English-speaking crowd, but we do have lawyers that speak French and that speak Spanish as well. So we try to cover the full lot, I would say.
Excellent. Thank you for that introduction. Find out more about Reis Pellicano in the Expats Portugal Business Directory. Before we conclude, I have got a couple of more general questions which are really helpful, and I think that we should include in here. And incidentally, a great testimonial as well. Thank you, Daniel and Andrea, who helped us too with our house closing and legalizing a building and getting us our bank accounts. A really happy customer here, handled everything superbly, professionally, and eased our minds that everything was legal. Highly recommend their legal services. and expertise. So unsolicited, which is probably quite a good word to use in this context, but an unsolicited testimonial there. So thank you very much for that. There was an earlier question, which I don't understand, but I suspect you will, Andrea or Daniel. What about direct pay on death, POD? I'm sorry, I don't know what that acronym is, accounts or beneficiaries outside of a probate process. Do you want to pick that up, Andrea? Does that, or do we need further clarification of what that might mean? That might be something from the US.
I can request a little bit further clarification just to try to
Yeah,
understand.
sure. Yeah, fair enough. So, Dwight, what about direct pay on death / POD accounts or beneficiaries outside of a probate process? We can pick that up after we've concluded the recording as well. Another question that came in, can the lawyer or notary provide the witnesses? Is that allowed? Good question from Ed and Sharon.
So notaries will not provide witnesses, nor will they provide translators. However, it is one of our tasks if the person comes to us and says, I do not have witnesses. Why is that? I'm not talking about translators, because not only we do the process of preparing the will itself, in the end and in the act, we will also provide, for example, translation services. So if you come to me and say, Andrea, I don't have witnesses, I can try to see if I can find 2 people that would be able to do that service for us. So
Perfect.
yes.
That's reassuring. Thank you for that. Let us know what POD, payable on death. Thank you very much. We'll come back to that in just a moment then. Jose, once done, I believe a will remains in effect forever unless it is superseded. Is that correct? We don't have to revise it unless something changes. That's a useful point.
Yes, the will. We can have just a simple clarification here in the statement that I want the law of my nationality to be applicable to all my assets, which one they are. In Portugal, you can do a will as simple as that. What do we advise? That you also rule your assets in Portugal. And going to the question, you do not have to alter it and update it if things are done properly. I'll say it that way. So if you say, I only have this house at this time and I leave it to someone, but then you sell the house and you buy another one, you should update the will.
Yes. Yeah.
However, if we do things properly, as I would say, you do not need to do that, because you can have a will for this asset or any other assets that I may have in the future.
That's really helpful, and I suspect that answers Jose's question there. Thank you for this, Colin. Should the UK will be translated to Portuguese and filed alongside? I guess this would apply to any other will from any other country nationality, and filed alongside the newly created Portuguese will.
It is not mandatory to do so, because once you choose the law of the nationality, and once you do pass away, what will happen is that notaries will have to go after everything there is, wherever there is. So that could be helpful in the future for your heirs, but it's not mandatory to do so at the moment. Your heirs can take care of that task in the future for you.
Very good. Thank you, Andrea. And we've got clarification. Banks in the US allow POD, that's payable on death, assets transfer immediately on death and do not go through a probate process, or beneficiaries of an insurance benefit, annuity, etc. So how does that work here? And perhaps you could say something about the probate process here in Portugal, if at all.
So here, one thing that we need to make clear is that choosing the law of the nationality and the possibility of stating what we want to do with the assets is only applicable to the Portuguese assets. So anything that is abroad, we are not able to establish in the Portuguese will, because, for instance, and in the first place, it should be stated by the wills that you have, for example, in the US. So we are only able to talk about Portuguese assets and what to do with them in Portugal.
Okay, thank you very much for that. We can dive deeper further into that later on, Dwight, if we haven't answered anything that you need to know on that. But thank you for that question, and thanks for answering that, Andrea. Couple of quickies then. Jim and Ellen, do the witnesses and lawyer and notary need to be in the same room at the same time? Which is an interesting question, but unworthy of inclusion, I think.
All at the same time, all in the same meeting. So everyone has to hear everything. We all meet, and all is done and all is signed in the presence of everyone.
It's fascinating, isn't it? So when people go into law in Portugal, they have to make sure they've got quite big offices for these.
That's it. So at least you'll have to have 4 to 5 people.
Yes, and then with the signings for houses with all the cousins, that's a consideration, isn't it? So big offices for lawyers here in Portugal. And yeah, thanks for this as well, Jerry. Can we have an approximation of the cost then, roughly speaking? Because I'm sure it will vary from case to case and how much work's required. But can you give us a ballpark estimation on cost?
Yes. It has to be a ballpark, because not only we are not able to know the costs of the notary, it depends on case to case. It depends on if you have more or less assets. So indeed, we are not able to know what to expect. However, I would say something between 1,000 to 1,500 euros to 2,000 euros maximum. I would say that would be the global price of the will.
And a lot of peace of mind that comes from that investment.
That's it. And that would be the most important thing.
Yes, absolutely brilliant. Thank you, Andrea, for the time being. Stay with us because we will stop live streaming on YouTube now. For those of you who have joined us on YouTube, thank you for being there. And consider becoming an Expats Portugal member, because you can be part of the post-recording session, which will start now over here on Zoom. So I'll